Ready, start. The total fine payable by the respondents dash convicts amounted to rupees 34,000 each and in default, they were liable to serve rigorous imprisonment for a period of 34 years. Full stop. The trial court had further directed that the single inverted comma substantive sentences single inverted comma close shall run concurrently, and that the period of detention, if any, undergone by the respondents dash convicts during the investigation, inquiry, trial, shall be set off against the terms of imprisonment, not being imprisonment in default of payment of fine imposed on the accused. Full stop. That as per the nominal roll of respondent numbers 3 to 13, none of them had paid the fine sentenced by the trial court, making them liable to serve the penalty of rigorous imprisonment for default in payment of fine. Full stop. But the respondents have neither paid the fine of rupees 34,000 to which each of them was sentenced, nor have they served any sentence in default of the non-payment of fine. Full stop. It was submitted that penalty of imprisonment ordered for default in payment of fine stands on a completely different footing from the substantive sentence of imprisonment to be undergone for an offence. Full stop. While under section 432 of the CRPC, the government has the power to remit single inverted comma punishment for offence single inverted comma close, the executive discretion does not extend to waiving of the penalty of imprisonment for default in payment of fine under section 64 of the IPC. Full stop. It was asserted that respondent number 1, while granting premature release, failed to apply its mind and address the determinative factors outlined by this court in Lakshman Naskar. Full stop. Thus, the orders of remission are vitiated by the vice of arbitrariness for non-consideration of relevant facts and factors. Full stop. According to learned counsel for the petitioners, a bare perusal of the orders dated 10/8/2022 would make it clear that premature release was granted mechanically and arbitrarily, without giving due consideration to the factors enumerated in Lakshman Naskar, qua each of the respondents dash convicts. Full stop. It was further submitted that it is tried that in cases where a convict has been sentenced to more than one count of life imprisonment, he can only be released if remission is duly granted as per law for each count of life imprisonment. Full stop. It is a matter of record that the respondents dash convicts were sentenced on 15 counts of life imprisonment. Full stop. However, the orders dated 10/8/2022 have not granted remission for each of the 15 counts and is only a generic and blanket order, making the release of the convicts illegal and arbitrary. Full stop. That respondent number 3 approached this court in writ petition criminal number 135 of 2022, without disclosing that he had already acted on the judgment of the Gujarat High Court dated 17/7/2019 and had submitted his application to the Home Department, state of Maharashtra, and that his application had already been considered by the authorities concerned, whereby, the major stakeholders had written against the grant of remission to him. Full stop. Further, when the matter was listed before this court, no notice was issued to the petitioner dash victim, and neither was she heard by this court in the matter. Full stop.